Okay. So, Howard, I'm going to introduce you if that's okay. So, for everyone else, welcome. Good to have you all joining us this morning. Oh, you are attending COVID compliance, what employers need to know now. And we've got Howard Jackson with us. Howard has been a friend to the Blount Partnership for many years. He presents on a variety of topics for us, so he is going to talk to us this morning. What we're going to do, if everyone's okay, is if you would just mute yourself throughout this presentation, interject any questions you may have in the chat, and at that time I will reach out to Howard and just say, hey, we have a question. And then at the end today, after he is finished, then you can open your mics and then ask your questions verbally. So mute yourself, ask questions in chat, and then verbal questions afterwards. So a little bit about Howard. Howard, I'm not going to read your whole bio, but one of the things I wanted to say is that his practice uh, has substantial experience with labor law, employment litigation, including both discrimination cases of all kinds and employee restrictive agreements, frequent training and counseling of employers on a wide variety of employment law issues and commercial litigation. And the other thing that I highlighted, Howard, was that you are listed in the best lawyers in America in the field of employment law management. So it is good to know that we know and we are self-assured that you know what you're talking about today, because this is troubled times and troubled waters for how companies navigate what's coming down on a federal level and then what's coming down on a state level. So with that, I'm going to turn it over to you, Howard.
Thanks, Tammy. It's always good to be with you folks. I look forward to the day when we can be forward more often in person, but I appreciate everybody showing up today. We're in a world that changes daily, it seems, and I'll even comment on that a little bit as we go along. But as what in the world are employers to do with all these rules that come along? I started this, did a presentation on some of these similar issues earlier when people were talking about going back into the workplace. The virus infections were trending down, et cetera. And so I said, well, why did my slideshow start? There it is. And so I wondered, are we there yet? Is it time to go back, and under what circumstances, and what do we need to do? And then we've had the increase in rates, the increase in hospitalizations up and down, the Omicron variant, and then both the federal and state government announced various laws and regulations, that some of which apply to some employers and some of which apply to others. And then the courts have blocked some of them. So I want to start out a little bit with where are we now? Where does that leave us in the situation that we're in? And I want to talk a little bit about differentiation between if you're an employer that has less than 100 employees, or if you're an employer that has more than 100 employees, and there's some reasons to differentiate yourself depending on that, where you fall on that line that we'll talk about. So if you're under 100 employees, you're under Tennessee law. The general rule under the law that the governor signed is that we can't have a vaccine mandate in Tennessee. That's the general rule right now under the law that the governor signed about a week or two ago. that in Tennessee, we're not going to have vaccine mandates. And clearly that applies to anybody who's under 100 employees. Now, there's an exception when the failure to mandate would result in loss of federal funding. That seems unlikely to apply now because I'll talk a little bit more about it in a minute, but the federal rules have been blocked, at least for now, by the courts. But there is an exception if you've already got it in a contract or otherwise, there's some situation that where if you don't implement a vaccine mandate, you're in danger of losing federal funding. You can apply for this exception. You apply for it via the Office of the Comptroller. When it's granted, the exception is for 1 year. And then you have an opportunity to apply again if things are still in place in terms of the federal funding requiring a vaccine mandate. The Tennessee law, by its own terms, expires July 1, 2023, at least in terms of the vaccine mandate portion of it. There's some other parts of that law that have to do with liability relative to COVID that don't expire then. But in terms of as an employer thinking about vaccine mandates, that piece expires July 1, 2023. So what about TOSHA? Well, so what does this mean if you're under 100 employees and you're wondering what should we do in Tennessee? We can't have a vaccine mandate, but nevertheless, we've got concerns about how we want to keep our employees safe. Well, under the federal OSHA and of course under TOSHA, which Tennessee administers federal OSHA, there's something called the General Duty Clause. Most of you are probably familiar enough, like OSHA has sections in it that are applied to the construction industry, for example, or to bloodborne pathogens. They have various areas of specific requirements depending on the industry you're in, the duty of the employees, that you have to comply with those specific requirements. If you're in construction, you got to comply with the fall protection, just for example, or if you're in certain jobs, they got respirator requirements. But if you're just in a general industry type work, you don't have any specific OSHA regulation section that applies to you. There's still in the OSHA statute something called the General Duty Clause. And the General Duty Clause requires all employers covered by OSHA, which is just about everybody, to provide a safe workplace. And so before all of these mandates came along and they're masking, the vaccine requirements, et cetera, OSHA in Tennessee and elsewhere had been proceeding under the General Duty Clause, which to me, quite honestly, made a good bit of sense because it's very difficult to have a one-size-fits-all situation with the virus. I mean, an employee who works in the bank is not facing the same things as the employee who works in a car parts manufacturer, who's not facing the same things as somebody who's working in a meat packing plant. I mean, it's just not all the same. And so OSHA had been proceeding under the General Duty Clause. And I won't go into tremendous detail about this, but under the General Duty Clause, what OSHA had been looking for employers was to do a risk assessment or hazard assessment, they call it, in your workplace. Where are the areas where our employees are more likely to face a risk of transmission or infection by the virus? And then once you've assessed the risk, you got that written down. Here's what we looked at. Here's what we found. Then you come up with a mitigation plan. Here are the 5 steps that we're going to take, however many there are. We're going to require masking, or we're going to put these barriers in place. We're going to stagger shifts. We're going to do this cleaning, whatever the various things that were and are that we're going to do to mitigate risk. Put those down in writing, of course, and then you monitor that. Check on it periodically. How's it going? Is it working? And in the situations, at least where I was involved, that maybe somebody called OSHA, some employee was bothered, they thought a company should have been doing something different or more. As long as an employer had a reasonable plan in place like that, OSHA might make a recommendation. Well, you're doing these 5 things. You might want to think about doing the 6th one. They weren't trying to cite people. They were being pretty reasonable about it. And then I saw not too long ago where OSHA did do an inspection and found some employers who just hadn't done their job, who were just ignoring life, and they did get cited, and that's reasonable. But so if that's a long way of saying, if you're under 100 employees, and really even now, given the blocking the federal law, which I'll talk about in a minute, we're under the general duty clause, and that's what you need to do if you're under that clause. Now, if you're over 100 employees, this emergency temporary standard has been blocked for now. We'll talk more about the standard in a minute. But a few weeks ago, the U.S. Court of Appeals for the Fifth Circuit, which sits in Texas, issued a decision that found various things that were not done correctly and that were not appropriate about the OSHA issuing this emergency temporary standard. Decided it should be blocked. There's this particular law where OSHA issues a standard of this nature that you can go directly to the Court of Appeals. And if there's more than one challenge in the Court of Appeals, then the challenges all get consolidated before one Court of Appeals, literally based on a sort of a ping pong ball lottery type situation. Somebody pulls out a ping pong ball with a number on it, and that Court of Appeals is the one that handles it. And that was done about 2 weeks ago now. And the challenges are before the United States Court of Appeals for the Sixth Circuit, which sits in Cincinnati. And that covers, generally speaking, it covers Ohio, Tennessee, Kentucky, and Michigan. But this Court of Appeals is now going to make a decision about this OSHA emergency temporary standard in terms of whether it's going to be blocked initially or it's going to be allowed to proceed initially. We don't know for sure when they're going to make a decision. The government filed a brief last week asking the court to uphold the standard and saying people are going to die if you don't, et cetera. And there's also been a request to have the hearing before all the judges in the court. Most of the time appeals are heard by a 3-judge panel, but the court can decide to have an appeal heard by all of the judges on the court. They haven't told us. The Sixth Circuit has not issued anything yet by way of scheduling briefing or saying whether they're going to hear it by all the Georgia judges on the court or not. So we don't know. Late last week, a judge in Missouri blocked the emergency healthcare standard, or the healthcare standard. And then yesterday, a judge in Kentucky blocked the federal contractor standard. So it would appear that all of us in Tennessee now all of those standards have been blocked for the time being under that OSHA issued relative to both healthcare and federal contractor, and now 100 employees and over. So there's a lot of the courts are not taking kindly to these actions. I see there's a couple of things in chat. Is that a question? Is there a question, Tammy?
One of the things was someone was asking what is an ETS, and I just typed in there emergency temporary
Yes.
standards.
Sorry.
But you might want to clarify that for those that don't know.
Sure, that's a good question. OSHA is allowed under certain circumstances to issue what's called an emergency temporary standard. Most of the time when the federal agency such as OSHA creates a rule, there's a rulemaking process, and they may print they create a draft rule, they have a notice and comment period where they publish the rule, and they have to kind of jump through these procedural hoops in order to issue a valid regulation. Because you remember the OSHA and other federal agencies take their authority from a law passed by Congress, and Congress gives the agencies the ability to create some regulations that implement certain standards that are in the actual law itself. And so there's procedural requirements for an agency to issue valid final regulations implementing the law that's actually in the statute passed by Congress. Under rare circumstances, which require that a variety of standards be met, OSHA can issue an emergency temporary standard. And for one thing, there has to be an emergency. And they tried to say that there was, that allowed them to skip all of the hoops, et cetera. And I think my next slide addresses that a little bit. Well, not the next one, the one after this. The emergency temporary standard basically says you vaccinate or test or else. It gives you the choice. We're going to talk about the standards a little bit that are in there. But this standard was published in the Federal Register in November 2021. There's 480 pages. Federal Register is a document that a lot of people don't see or worry about, just lawyers and some others. But among other things, if that it has in it are proposed regulations by any agency. And what the agency does is they don't just publish the proposed regulations themselves. That's pretty short. This document, though, has a lot of information about why there's an emergency, why we need to have an emergency standard, what's happening with the virus, what's happening with the vaccines, what's going to happen if we do this, what's going to happen if we don't do this. And clearly, to me, what OSHA did here is that they knew that as soon as these proposed standards were published, there were going to be lawsuits filed to challenge the emergency temporary standard. And they kind of stuffed into this document all kinds of stuff, all kinds of information that they're going to use in trying to convince the courts to say that they're allowed to have this emergency temporary standard. And that's why there's 480 pages on it. Interestingly enough, the CDC has decided to make a comment on the filing in the Federal Register. They recommend reading all pages as a cure for insomnia. I mean, it's just goofy how much stuff they've put in there. But that's the reason, because they were anticipating this fight that they have now gotten themselves into. And at this point, that rule is blocked. So what's going to happen? The trend right now is that the standard is being blocked, really in all, not just the emergency temporary standard for industry, but the contractor as well as the healthcare. So, the courts are trending towards not liking it that much. The Court of Appeals, Fifth Circuit issued a stay, now before the Sixth Circuit. We don't really know though what's going to happen, and so I think it's worth understanding what's in that standard in the event that you need to comply with it later on. I suspect even if it is upheld, what you'll see is that OSHA will change deadlines and such because of the delay caused by the appeals. And in fact, just the other day, when it came to federal contractors, before that standard was also blocked, the executive department and OSHA issued a statement saying that they were going to delay implementation of the standard and any penalty under it because such a high percentage of folks had been vaccinated. So this is going to continue to be sort of a moving target. So what's in the standard? Tennessee has a state plan. It's one of 22 states that you have a state agency that enforces OSHA. Under the emergency temporary standard, it's been blocked. We'll talk about what's in it in case it gets unblocked here pretty soon. States such as Tennessee have up to 30 days to either adopt the federal emergency temporary standard OSHA put out, or an alternative that is at least as effective. The clear sort of impetus from OSHA on this is that it seems obvious to me that they want the states to just simply adopt what OSHA has proposed. That's the simplest thing to do. And if you do something else, you're going to examine it and try to determine if what you propose is at least as effective as what they have put into place. The federal emergency temporary standard applies only to 100 employers of 100 or more employees. That's why I made that differential earlier on. If you have 100 employees or more, or do you not? In Tennessee, as well as in other states where you have a state plan, this 100 or more line is going to include governmental agencies. Oddly enough, if you're not a state plan, it doesn't apply to governmental agencies. So that's one little wrinkle if you're in a state plan. But so here, if you're a governmental employer of 100 or more and this standard sticks, then you're going to need to comply with it. How do you know if you have 100 employees? Well, you count all U.S. employees. So if you have 60 employees in the U.S. and 1,000 in Germany, you don't have 100. You count your U.S. employees. Part-time employees count. So if you got 70 full-time and 31 part-time, you've got 100. So you count all of your U.S. employees, full and part-time, to determine if you have 100. Staffing agencies are considered separate. Yes.
Can I interject a question there?
Please.
In the chat, it says, does this just apply to private business or publicly owned business?
Well, both. It's both. Yeah. If you in Tennessee, it's both. If you have 100 or more, this standard is allowed to stand, you're going to be covered, regardless, private or public.
Okay.
Okay.
Mm-hmm.
All right. Now, again, sticking with, do we have 100 or not? The staffing agency is separate from the host employer. So if you are a manufacturer and you have 80 employees of your own and you have 40 temporary employees, you don't have 100. They're gonna look at you separately, and what they're gonna look at is that does the temp agency separately, do they have 100? And so that's the way this breaks down. Independently owned franchisees are separate from the franchisor. So if you have 2 Subways and 50 employees total, you don't have 100 as a franchisee. They don't count Subway corporate employees along with you.
And Howard, a question from the group was, how does this apply if a business utilizes a PEO? I don't know that I know what's a PEO.
Professional employer organization.
Gotcha.
And so it may be, it's a way that you can structure how you're going to handle your payroll and HR and such. And so what they're going to do is look at if you as a business, your business, have 100 employees, they're not going to aggregate you with everybody else who's aligned with the PEO service. They're going to look at what you as an organization have. And so if you're if you sign on with a PEO that services a lot of different companies, they're going to look at your company separately from the aggregate total. There's some workplaces that are exempted under the proposed standard. If you're covered by the Safer Federal Work Guidance for federal contractors, for subcontractors, or the healthcare services subject to the healthcare emergency temporary standard, both of which within the last week have also been blocked. So it can change that. Stay tuned, because there's news sometimes daily and at least weekly, it seems. There's such a thing as exempted, those are exempted workplaces. Now there's also such a thing as exempted employees. So if you do not report if an employee does not report to a workplace where others are present, it's sort of hard to imagine how that might happen. But that's one of the statements in it. If you work from home, while working from home, you're exempted. Now there's a little bit of a wrinkle to that. Let's say that I work at home every day of the month, except one day a month I have to come into the office. for a staff meeting or sales meeting or whatever it may be, if this standard comes into place, then I'm going to either need to either be vaccinated or be tested within 7 days of when I come in for that office meeting. Don't have to be tested every week. You go to the testing option, because in times that I'm working from home and not being with anybody, that's okay. Also, if you work exclusively outdoors, and the word from OSHA relative to this emergency temporary standard is that they're going to view this exception for working outdoors very to the letter of the law, if you will. So if you're a construction employer and you have a trailer on site and you have a pre-shift meeting and everybody goes inside the trailer, OSHA was going to take the position that these people don't work exclusively outdoors. They have an indoor meeting. So that you would want to do, silly as it may seem, you maybe want to, if you want to get those people out from under the standard, you want to have your pre-shift meeting outside so that they work exclusively outside. That's the word OSHA put out in terms of how they're going to view this this exempted employee category. So the standards also require that an employer establish a policy in both language and wording employees can understand. And what they mean in language and wording, part of the language means if you've got a lot of folks who speak a language other than English, then you'll need to have your policy in more than one language. And then it needs to be in phrasing that employees can understand. And there's certain things that the policy is supposed to include. You have to report a positive test. I think most of us probably require that already anyway, just as part of trying to keep our people safe. Employees who test positive removed from the workplace. Again, that's probably what most of us are doing already. Whether you're unvaccinated or not fully vaccinated, you have to wear a mask indoors or when in a vehicle with another person. I think that's a pretty typical requirement already. A lot of employers. These things just have to be in a policy now under this standard. Provide information regarding the emergency temporary standard. There's a handout that can help you with that. OSHA's already put together. Workplace policies and procedures. There's my typo, COVID-19. Sorry about that. Some information about vaccination efficacy and the safety and benefits of the vaccine. So kind of the thrust of this is this standard would sort of force employers to put into the hands of employees information that says, hey, the vaccine's safe and it works well, and so we really need to do it. That's kind of the thrust of it. Protection against retaliation, in other words, if you report violations. And then information in the policy has to let employees know that there are laws providing criminal penalties for providing false documentation. We'll talk more about that in a minute because that relates to the testing option primarily. There's a document that has already been put together about vaccine efficacy, safety, and benefits, etc. Key things to know, and it's available at that on that site. I'm giving you the link where you can just get it. It's pretty well put together. So if this standard comes into play, it would be an easy thing to do to just go there, print this out, put it on your intranet or hand it to employees or however you want to use it. There's no need to reinvent the wheel on that part of compliance. Certification and record keeping. By January 4, you're supposed to have a roster of employees by vaccinated or not vaccinated. Again, given the challenges, if the ETS is allowed to stand, I think the dates are going to change. Though the requirements will stay the same. This is simply for the employer to have Bill Jones, Susie Smith, etc., and a list that said, yes or no, vaccinated or unvaccinated, or V or U, however you want to do it. You just have to have that as a roster of your employees. Then employees would have to provide proof of vaccination. They couldn't just they can't just verbally tell you. And these are the kind of documents that are allowed. A record from a healthcare provider, a copy of their vaccination record card, any kind of medical record, immunization record from a public health, state or tribal system, any other official documentation, or a signed and dated attestation. The employee can give you a statement, but there's requirements of what it has to say. The employee just can't say something vague, I'm good or something. Just you have to state the vaccination status. It has to say that the employee lost or is otherwise unable to provide proof, declared as being a true statement with knowledge that criminal penalties apply for providing false information. And this is sort of interesting to me. I just saw a little blurb yesterday where I can't remember which organization it was now, if it was the Human Resource Management or another one, but it had taken kind of a quick poll of employees, and it was something like 25 or 30% of them had stated that they would be willing to provide false statements to their employer relative to vaccination status if there is to be a vaccination mandate in order to keep their jobs. So that's just an interesting anecdotal note that this law attempts to prevent that by saying there's criminal penalties, but yet there's a significant percentage of employees who are willing to admit in a survey that if it comes right down to it, I'd be willing to just lie about it and say I'm vaccinated if I'm not. So commentary on where we are, I guess, as a society, and on possibly on the how effective such a mandate would be if people are willing to just tell you lies anyway. The employer has to have a roster of employees, vaccinated, unvaccinated. When the employee gives you the document, the medical record, the public health agency record, the attestation, whatever they give you, just verify that they've been vaccinated. You keep a copy of that document, keep it separately from their personnel file, the same way that you do medical files under the ADA. You just keep that separately. Availability of records. An employee can come to you and say, all right, I want to see my own vaccination record or test result. Or the an employee or a representative of employees can request the aggregate number of fully vaccinated and total number of employees. One employee cannot see another employee's vaccination record. What this requirement is for example, we have 150 employees, 125 are vaccinated. So it's an aggregate number. It's not information about any individual employee and their status. But under this emergency temporary standard, you would be required to keep the record of who's vaccinated and who's not. And then upon request, tell an employee the number, how many vaccinated, how many employees total, and how many vaccinated. Employers are to provide paid time to receive the vaccine up to 4 hours, paid time off to recover from the side effects for what they call a reasonable time. The regulation itself doesn't say what a reasonable time is, but OSHA had kind of put the word out that they generally need 2 days to be enough. So if somebody goes and gets a vaccine and gets sick, they can get a little, up to 2 days time off work paid. Now, if you get the vaccine on Friday and you don't get sick till Saturday and you're back on Monday, it would only be time when you would otherwise have been working. You don't get paid time off just on the weekend when you would not have been working anyway. This is an interesting wrinkle. I don't know why they took this position, but it's just there. So I wanted to include it for you. You're not allowed to charge a leave bank for time away to be vaccinated, but you could charge a leave bank for time off due to side effects. So if they go, I'm going to go to CVS during lunch and I'll miss an hour of work, just pay them for the hour. If they're non-exempt, if they're exempt, it's not going to matter. But then if you say, okay, I got the shot this morning, I got to be off this afternoon because I'm feeling sick, you can charge their leave bank for the sick time that afternoon. But so just a little difference in how you, under this regulation, allowed to treat that time away. Medical and religious accommodations under the emergency temporary standard, these are recognized. So Americans with Disabilities Act, somebody presents information noting that they are having a vaccine is not indicated for them for a health reason. The same kind of process that you would normally go through is what would be required. You could require reasonable documentation. In this situation, a note from the doctor or healthcare provider saying that Billy Jones should not be vaccinated for health reasons is enough. Tammy, did you have a question?
Yes, I did. One of the questions, this was on the leave time,
Okay.
on the previous slide, but leave bank equals their own paid time off.
Yes. If you have a PTO, a vacation, a person, however, employers treat these in a lot of different ways, whether they call it paid time off or vacation, or they differentiate with personal days or sick days. There's a lot of different ways people do it. But if someone under this standard, if it comes into play, takes time away due to the side effect, and you are allowed, you don't have to, but you're allowed to charge their personal time, their vacation time, their sick time for the time that they're away. That answer the question? Okay. Okay, so if somebody provides a note from their doctor, their healthcare provider that says Billy Jones should not be vaccinated for health reasons, most of the time that's all the information you're going to need. And then you engage in a process of determining, what can we do to reasonably mitigate the risk both to this employee and others. And that in the majority of situations, that's going to come down to wearing a mask, social distancing, cleaning, and steps of that nature. And in most situations, that's going to be enough. If you've got an employee who's in a circumstance that for whatever reason, they're not being vaccinated creates significantly more danger for whatever reason, then you just have to continue the analysis. Can we put this person in a different position? Can we swap off some job duties? Can we put extra steps or procedures in place to increase the safety? It's the same sort of analysis that you would go through when people make an accommodation request. And in the great majority of situation, you can figure it out easily enough. But the process is the same as with ADA. Similar thing with religion. You can ask some questions to ensure that the basis for the exemption request is in fact religious. The EEOC has put out a form that they use, and you can just, instead of saying EEOC, you can just insert the name of your organization and use that form. I can send it to you, or you can get it off the EEOC website. It's very easy. But the thrust of the form is to explain in simple terms the religious basis for the employee's request. And the object here is not to try and question whether or not the employee's belief is correct. I mean, I was doing this talk not too long ago before a group, and one of the people said, well, somebody put such and such a reason down, and I know that that's really not right under the scripture and what have you. I'm like, no. We're not trying to make a judgment call about whether they're correct. The only thing here is it actually a religious reason? because the people write down, well, that invades my right to privacy. Well, that's not a religious reason. Or they'll write, it violates my constitutional rights. Well, that's not a religious reason either. If the employee puts on this form a reason that is connected to their religious belief, that's it. That's all we need to know. And then you engage in sort of the accommodation analysis. The bar is a little bit lower with religion. You don't have to spend money. You don't have to pay people overtime to work shifts when somebody else otherwise could work, et cetera. But it's, other than that, it's a very similar analysis as with ADA. And you just try and figure out, can we mask? Can we rotate times? Can we have physical barriers? What can we do to reduce the risk based on this individual not being vaccinated? Both of those exceptions are recognized. Like
Howard,
yes.
One comment was, I've heard the term of personal conscience, especially in Texas. Can you speak to that?
I don't think personal conscience is a religion. That's kind of a gray area, perhaps. But a religion relates to some system of belief that is in some way recognized, not just I don't like it. It sounds like a way to try to shoehorn your personal objections into religion. And I think most people that want to take this route are being wise to it and writing down a religious reason, whether that's really what they think or not. That's just a reality, I think. But I wouldn't personally tend to quibble a whole lot over the religious objection piece of it. As long as it's plausibly religious, I don't want to be the test case of whether this is actually right or not. If I'm an employer, I'd rather try to work it out on a cooperative basis than be at the Court of Appeals in 3 years from now, spending a bunch of time and legal fees over it. That's just my sort of practical 2 cents about it. Okay. Testing option under this standard, again, it's been blocked, but in case it comes into play, the OSHA emergency temporary standard would allow employers to require either proof of vaccination status or weekly testing. Now, if we just talked about folks that have a vaccination exemption under ADA or religion, then they need to be tested. And again, with the exceptions mentioned earlier, for example, people working at home, they don't have to be tested if they're exclusively working at home, but the rest of folks who need to be tested. It applies to employees who report to workplace at least every 7 days. If you report monthly or occasionally, you're supposed to have a negative test within 7 days of when you report, which is sort of odd in a sense, because you can get tested on Monday and be negative and report to work for your meeting on Friday and having been infected on Wednesday. So I don't know. That's one of the concerns under this standard, but that's what it says. What test we use is it's test to be approved by the FDA to determine current infection. There's quite a few of those administered in accordance with the instructions. Test cannot be both self-administered and self-read. It can be observed by the employee. The employee can self-administer the test, but then the employer or a telehealth doctor would have to read the test. So you can, let me put this on the slide, next slide here. Yeah, over-the-counter tests can be used as long as they're FDA approved. So you could buy a bunch of tests, have them at your workplace, let the employee self-administer it, and have somebody read it there. So you can sort of make it efficient and cheaper if you want to take the testing route by doing it in that way. And you can do that now if you like. Yeah, and you can allow employees to self-administer and then just review it in the employee's presence. So you can do it at the workplace which removes any kind of issue about payment of the employee's time. Employees can request exemptions from testing for health and religious reasons. I'm not really heard of that much. You try to be exempt even from testing, but I guess in theory that could happen. Here's the question: who pays for the test? Well, the emergency temporary standard doesn't say, which puts employers in a pretty awkward position. The federal government says you have to either be vaccinated or tested, and oh, by the way, we're going to make you pay for the test if you don't want to be vaccinated. And meanwhile, we're in the Great Resignation, and employers are screaming for employees everywhere. So I think, as a practical matter, most employers are going to figure out a way to pay for the test if the testing option is selected. Now, you don't remember if this standard is upheld, you don't have to offer a testing option. You can just require vaccination. If you choose to offer a testing option, these are how you do it. It's got to be FDA approved. Employee can't self-administer and self-read, although they can self-administer and you can read it. But how are you going to look at folks and tell them they got to pay for it? I think most employers that choose testing as an option probably are going to end up paying for it, and that may impact the choice as to whether, well, we're just going to go with the vaccination standard because we don't want to spend all this money testing people every week. I mean, even if you get relatively cheap over-the-counter tests and do them at work, if you got 1,000 employees and you're testing them every week, that is a lot of money real quickly. Like the Fifth Circuit mentioned that in their blocking of the standard, that was very problematic. Who pays for time spent testing? If you test at work and have the employer read it right there, generally not an issue. They're at work. If people are testing away from work during what would be their working hours and even sometimes not, it appears likely the employer is going to be required to pay for that. The Department of Labor has not come down with a definitive standard on it, but that's our read on it, is where they're going to land. And so that again counsels much in favor of getting over-the-counter tests and having them administered at work, so that you don't run into not only the administrative nightmare and the cost of having people away from work and then say, now you got to pay me. You're going to CVS for a half hour to have this test done. You just do it at work and avoid that. This would be the better option. Under the standard, employees who are not fully vaccinated must mask. This applies regardless of the reason for unvaccinated status. Interestingly enough, under the standard, it doesn't say much of anything else about if you're unvaccinated. If you're unvaccinated, then you're required to mask at work. And it doesn't say anything about barriers or cleaning or social distancing, etc. You mask. There's reporting requirements. You have to report the COVID-19 fatality within 8 hours of learning, work-related COVID-19 fatality, and a work-related COVID-19 inpatient hospitalization within 24 hours. The big question here to me is, how do you know it's a work-related COVID-19? I mean, you can get it anywhere, the grocery store, at home, because your person you live with has it, all kinds of places. So how do you know that it's a work-related COVID-19 issue? And my thinking on that is that unless you've got some really good specific reason to know that it actually is work-related, maybe one person in an area is infected and you know that the 3 people that work right with them got also infected within a day or 2 later, something that really points to it, then I just wouldn't report it. But if you have something that very clearly points to that this infection being work-related, then I would meet this reporting. There's no specific guidance. If you happen to be a unionized workplace, you want to check your collective bargaining agreement as far as what it has to say about implementing changes in compliance with the law, etc. communicate with your local and, if necessary, district leadership team of the union. The reason, for those of you that may not be as familiar, in the unionized workplace, an employer cannot unilaterally implement changes in terms and conditions of employment, and obviously a vaccine mandate is a change in terms and conditions of employment. Generally speaking, though, both the employer and the union are required to comply with any legal requirement. You can't just say, well, we have a union here, so we're not going to follow the Family Medical Leave Act, whether it's in the collective bargaining agreement or not. You have to follow it. But what happens is how do we handle the questions about implementation? We're going to allow the testing option. Are we not? If we do, how's that going to be handled? There's all kinds of sort of implementation questions that you would want to be in communication with the union about, and try to work through that in a cooperative manner in the event that you have to deal with that. You wouldn't be able to just say, hey, we in the union are going to agree we're not going to follow this legal requirement. That's not what I mean. But you just have to navigate how it's implemented if you're in that situation, and you'd have to negotiate over that in that situation. All right, so that was a quick run through of a lot of stuff, and I appreciate your questions along the way. And if you have some others at this point, I'd be glad to hear them.
So, Howard, so you've cleared a lot of things up, but what it's clear to me is it's still very confusing to know what to do.
Yep.
So, can you summarize, like, if you're over 100 or less, here are 4 or 5 things you need to look at, or do we just say, hey, if you're unsure how you need to proceed, call Howard or somebody to help clarify?
I can throw out some things there. I think if you're over 100, that the smart thing to do would be to get your policy documents ready, get yourself set up to be able to have your employee roster of vaccinated or unvaccinated. Get yourself ready in terms of how you're going to communicate in the event the standard is upheld. Make a decision about whether or not you're going to, if it's upheld, whether or not you're going to allow the testing option. And if you are, figure out how you're going to handle the testing process. Are we going to contract with this group and send people over there? Are we going to buy over-the-counter tests and have them at the workplace? What is our process going to be if we elect, given that we're going to elect to have the testing option, and just have those things in place and ready to go in the event that it's upheld, and then wait. But those are the things you can do in the meantime, is just get your policy ready, make a couple of decisions on which way you're going to go about allowing testing or not, and if you are, how are you going to do the testing arrangements. So get those things in place. It's not terribly difficult to do, and then wait. And if in all employers over and under 100, in Tennessee right now, you don't have a mask mandate because the law says you can't. And then you follow the OSHA general duty clause for your workplace. Have a hazard assessment, have a mitigation plan. What are we doing? You probably already have that because of how long this has been going on. But if you don't, it'd be a good time to get it done, and then work your plan. So those are the 4 or 5 steps you can go ahead and take now.
I feel like you just answered this. Somebody was asking, do businesses under 100 need policies in place too? And what I just heard you say is
Not under the emergency temporary standard. I mean, it's always a good idea to have good communications with your employees, but you're not legally required to have a COVID-19 specific policy under the emergency temporary standard if you're under 100 employees.
I also get, I don't know if others on this Zoom have the same issue, but I always get confused when federal's saying one thing and state is saying something maybe different.
Yeah, that's always fun, isn't it? If the emergency temporary standard is upheld, it would override because of the supremacy clause. And so that's the question now, is you got these conflicting laws, at least 10 conflicting laws out there. Which one stands? Well, the federal standard's been blocked right now. So for now, the Tennessee standard stands. But if the federal emergency temporary standard is allowed to go into effect, my view certainly, and others I've heard, is that the supremacy clause would come into play and the federal standard would apply. But that sure puts employers in an awkward situation. You got somebody from Tennessee coming in saying you're not supposed to do that. I don't think that's going to happen. I think it's a principled statement by the state and the governor that we don't want the feds coming in here telling us this, but I don't think they're going to take the Tennessee government is going to sort of take it out on employers who are put between a rock and a hard place if they're following the federal rule.
Not to mention the fact that all of this costs money to businesses one way or the other.
It sure does.
And
well, yeah, if the vaccine mandate comes into play, you got to put the policies into place. The vaccine itself is readily available and commonly free in many situations, but you still got to deal with the policy and the cost of administering all this, and so it's an additional burden either way you look at it.
There was a comment or a question. Howard, do you care to provide the PowerPoint to those that were on today, or if you will provide it to Amy, we'll make sure to get it out to everyone. And also for those on the call today, we have recorded this and we'll have it available for you to review later if you need to, or if you need to send it to someone else in your organization. At this time, let's give it a few minutes and just open up your mic and ask a question. No need to put it in chat, not unless you just want to. And Howard's agreed to camp out for a little bit if anybody has specific questions. And Howard, if somebody has a question that really is private to them, could they reach out to you?
Sure, just send me an email or give me a call.
Okay. Yeah, so there's Howard's contact information there. Anybody else with questions?
Maybe I put them to sleep. They're just all...
No, you didn't. No, you didn't put us to sleep. We're just trying. I think we're all just trying to digest.
Shell shocked. Yeah.
Well, it's just a lot. Is there a grid somewhere that says if you're this is what you need to do? If you're this is what you need to do. If you're this, and this, is there anything out there like that, Howard, that would be helpful to small and large business?
I don't know that there's a grid. It's just, again, as I said, the 100 and over has potential standards, and then the federal contractor and the healthcare standards are put out there earlier, and so I think most of those folks in those worlds have digested all that. So I don't know of a grid like that.
Well, if someone comes across that, let us know. We would be happy to push that out.
As soon as you send it out, one or more of them will change in the next week.
Absolutely. Okay. Well, thank you all for joining us today. There was there's a question for you, Howard. What do you think the chances are of the mandate taking effect?
My impression, and it's just that, is that I think the Sixth Circuit is going to block it, and that we're going to end up before the Supreme Court.
Well, if that's the case, we're talking about something that's way, I think
we'll hear from the Sixth Circuit this month, and I think we'll get before the Supreme Court probably next month. Because normally it takes a long time to get there, but with issues of this importance, it's not going to surprise me if we hear quicker. much quicker than usual. That's my reading of the tea leaves.
There's also a question here that if for companies that are under 100, do they need a mask policy?
I think at the 10,000-foot level, yes. I go back to the OSHA's general duty clause, and I'll just use it where we are, for example, in our building. Now, if you're just what the building policy is, not just for us, that they expect, if you're fully vaccinated, they're not requiring a mask, and if you're not fully vaccinated, they want you to wear a mask in common areas. And that's kind of what we've done within our office, is that if you're fully vaccinated, we're not asking you to wear a mask. If you're not, we ask folks to wear a mask when they're in common areas, not while necessarily just sitting at their desk. But that's the kind of thing that you need to analyze, at your workplace. So what's the most appropriate? What's right for a restaurant or a bank might not be right for an accounting firm, which might not be the best thing for a manufacturer. So I think you need the general response is that you need to put safety practices in place with respect to the virus that fit your work environment.
And then also there is a question here about unemployment benefits related to COVID policies. Do you know where someone could find out more information on that topic?
Sure. The state law that was recently passed by the governor says that if somebody quits or leaves because of a vaccine mandate, then they're going to get unemployment benefits. So it's right in that law, that provision. And then if somebody is required to stay away from work because of their COVID status, and it's long COVID or what have you, they're on layoff or a long leave, they would be able to get temporary unemployment benefits. And I don't have a link for it, but I believe there is guidance in the Tennessee Department of Labor and Workforce Development relative to that subject on their website. I'm sorry I don't have a link for it right with me, but I believe they have a little bit of guidance about that for us. And then again, that recent Tennessee law makes it clear employees discharged for refusing to be vaccinated get benefits.
How does that play, Howard, with Tennessee being I don't know what's at will
Employment
state?
at will.
Yes.
Well, you can, if you discharge them for refusing to be vaccinated, you're violating the law right now. But in general, you can let somebody go, and they can't sue you unless it's an illegal reason. But that situation and whether or not they get unemployment benefits is a totally separate analysis. They're very different standards under. Do you have a lawsuit versus can you get unemployment benefits?
That doesn't really make sense, though, does it? It seems like a conflict to me.
I understand that, but it's just unemployment benefits, generally speaking, are if you lose your job, we're going to help you get some money, unless you did something really bad to cause yourself to lose your job, like just stay in bed and never show up, or go in and slap your supervisor or whatever. Versus under Title VII or the Tennessee Human Rights Act, the question is, were you discharged for some illegal reason? So they're just different legal settings.
Any other statements or questions anybody would like to ask while we have Howard with us? Well, if not, then folks, have a great day. Howard, if you could hang back with me for just a moment.
Sure.
And we will be following up with you all on today's recorded presentation as well as the PowerPoint. So you all have a wonderful day.
Thanks, Tammy.